having these distinguished speakers and Meltem here, I would like to ask you all a question that came up in my mind when I was listening to Meltem's presentation, and there's a related question as a follow-up to mine, the upcoming question on that from the audience. So as you mentioned, there is the definition of the status of gig workers. So in some jurisdictions, they are recognized as individual contractors. In others, they are recognized as employees. To give a Swiss perspective, in the Geneva region, the court decided that Uber employees were actually employees, not individual workers. So they would fall under the labor law, and the way they worked, the conditions under which they were working, were against the labor law in the Geneva region. So Uber was prohibited from from operating in the Geneva region in Switzerland. So I think several other countries had similar cases, court decisions. Doesn't this affect how competition law and competition authorities address these issues, these kind of competition issues in labor markets? But to my understanding, I'm not a lawyer, but I think this goes beyond the scope of the law and the competition authorities, isn't it? It is the way you define gig workers also determines the way or the possibility, if any, that competition authorities can intervene or cannot intervene. Because if they are considered as employees, to me it seems easier to intervene as competition authorities. But then if they are individual contractors, then there are issues like hub and spoke cartels. That can they coordinate? Is it competitive? So actually the debate moves in another direction than the wage discrimination, that everything we discuss with the speakers. So in that case, maybe there's a role for competition authorities to advocate in their countries for these workers to be recognized as employees. What do you think about it? And yeah, the similar question from the audience related to mine is as follows. If we accept the Uber drivers as employees, then aren't they subject of employment law rather than competition law? Slightly different question on that. What do you think?
I could say a few things about that, if that's all right.
Yes, Marshall.
So I think the employment status, legal status of employment question is very important, but I don't think it's dispositive as to the application of competition law. I mean, you all have mentioned cases of no poaching agreements that pertain to employees. I mean, it's basically the economics of the case, or regardless, the entire case is not hinge entirely on the fact that the workers are or are not employees. They are still subjected to the same anti-competitive behavior between employers. I guess where it seems to matter most would be where you've got the treatment of, you have a dominant employer, a platform, say, and the question is, well, are they allowed to set the prices for these transactions? They can't, if they're talking about their own workers, of course, they can set the prices because it's all just one company that can set its own prices. I mean, subject to the other restrictions of that competition law might bring into the case. Whereas if they're a separate entity, then at least my view is there should be more scrutiny of that. I think it does. I don't agree with the state. I mean, it may legally be the case that it's easier to intervene if the workers are employees, but I think economically speaking, there should be more of a impetus to intervene when they are not employees. That is, when the legal status is such that these are two different entities. To me, that is exactly where competition law should be brought to bear the most, because this is the area of law that regulates the imbalances of power and its potential ill implications across the boundaries of the firm. I think that's at the foundation of the diminution of labor power more broadly, and in particular the spread of the gig economy, is exactly that there's a sort of gray area that pertains to where the legal boundary of the firm is, where you don't, where dominant employers are neither subject to labor law nor to meaningful competition enforcement, given their ability to impose vertical restraints. Finally, just to wrap up this, Commissioner Rebecca Slaughter of the American Federal Trade Commission did submit a comment. So right now there's a rule going through the Federal Department of Labor. I don't know exactly what the status is, but I suspect it's near its completion, that would essentially ratify the treatment for the purposes of federal labor law, the treatment of gig workers as independent contractors as opposed to employees. And Commissioner Slaughter articulated, in my view, a very strong case why that pertains to competition and would have the effect of reducing competition in labor markets for disadvantaged workers. And so she was, I mean, the context there is saying that treating these workers as employees would promote competition in labor markets coming from the Federal Trade Commission or a commissioner of it.
Thank you, Marshall. Anybody else?
Yeah, I'd like to add just a comment. The fact that a worker is a worker, an employee, or an independent worker has an effect on how antitrust law can intervene on its specific behavior. So trade union negotiations are not subject to antitrust law, but of course, no poaching agreements, that is behavior on the part of the companies purchasing labor, are of course subject to antitrust law. And with respect of contractors, contractors are like firms, so also their association or any type of practice they put in place, coordination or any part, they are like firms, so they are subject to competition law. And indeed, there are old cases of the European Union. I refer to the Italian harbor workers. Is a very famous case of 1991, referred to the port harbor of Genova, where the Commission intervened against workers at the harbor because they were fixing wages, but effectively these workers were not workers, they were contractors. So they were fixing their contract fee. And in this way, they were actually like a firm, and they were subject fully to competition law. So the issue was, in that particular case, was a case brought by a ship owner against the harbor of Genova because they were not allowing to use his own workers or other contracted workers to download his ship because of there were some exclusionary practices that were exclusively given to the identify the workers in the harbor of Genova. But these were not workers, they were contractors. And so in this way, this practice could be addressed by competition law. So I'm saying that, all I'm saying is that if a worker is a contractor, it's fully subject to competition law, including its own practices. On the other hand, if it's an employee, only the practices that affect him, practices by companies, could indeed be subject to competition law, while practices by the worker themselves are not, because, for example, Article 101 and 102 of the European Treaty, which are the main antitrust legal provisions in Europe, and there have been similar provisions in all over the world, they effectively refer to firms as being the subject, the object of the provision, not anyone. France, for example, has a different provision. It's much more open, for also Australia, by the way. So they do not refer to firms. And in fact, in these countries, in these jurisdictions, there has been some idea or even some actions which have been undertaken against trade unions themselves, because the agreements are prohibited. Agreements that restrict competition, not necessarily agreements by firms. So it depends on the legal provision, but in general, legal provisions are directed towards firms.
Ebru, can I contribute?
Of course, please, Meltem.
Thank you. My contribution would be, since this with the digitalization and with these platforms, we have totally a new world. All the categories that we used to know are no longer available. All the standards we are applying to them are no longer sufficient enough indeed. If you look at gig workers, so there is no one homogeneous category as gig workers. If you look at Uber drivers, indeed, they're quite different than Airbnb hosts, because Airbnb, you're free to price your house the way you like, the time and everything. Instead, in Uber, Uber drivers get instructions from the Uber, so the price is almost like fixed by the algorithm, by the company algorithm. Or if you look at TaskRabbiters, they are free to put the price on their task the way you like. So there is no one specific category of a gig worker. And this is true also with the other types of competition issues in digital markets. If you look at abuse of dominance cases, and we have difficulties and challenges in naming those conducts now that we used to in the past. We would say predatory pricing, or this is an excessive pricing, or this is an exclusive agreement. And instead now we have exploitative abuses, which were, as Lina Hahn yesterday suggested, we have to move towards exploitative abuses. So the gray area, or the fine line between competition law meets consumer protection law seems to be blurring the boundaries. So we have to be, from my understanding, we have to change our mindset a little bit, and we have to, rather than just naming or trying to come up with the old solutions, we have to be finding new tools and new amendments. Maybe we have to refresh our existing legislations in order to answer the needs of these problems. That would be what I would say. Thank you.
Thank you very much, Meltem. That was a nice exchange, actually. We have another question. Maybe we can end with that, with this one, specifically on transaction costs approach presented by Alberto. So I'm reading the question. You can also see it in the Q&A on your screens, but I'll read it for all the audience. Isn't the transaction costs approach assuming too much that the undertakings are substitutes for structuring efficient transactions when markets fail? Aren't undertakings legitimately focusing on very many other goals and preferences while governing certain kinds of economic activities through a logic that's very different from that of a market? Would you like to react to this, Alberto?
I didn't quite. It's not within of course, within the firm. The firm acts outside of the market. It decides internally how it wants to organize itself. But relationship with other companies, other suppliers, and consumers also are market-based. So I don't understand well what it means by when the person that asked the question says that firms have different objectives. Of course, they can have any objective, but the issue that I'm concentrating on is that the relationship that exists between the firm and its buyers, and the firm and its suppliers. And in both instances, in our view, antitrust law is there to make sure that sunk cost investments on both sides, on the consumer side and on the supplier side, is not exploited by the company itself. And it can do so only if the company becomes dominant, either unilaterally or in a coordinated fashion, and only if there are no other ways to protect that sunk investment through contracting, or considering also the choices that the consumer or the supplier had at the time the decision to trade with the company was undertaken. So you have to see whether it was a mistake by the supplier or a mistake by the consumer not to be cautious enough as to be subject to hold up, or whether it was an action strategic action by the company itself to engage in hold up. So we want to exclude stupidity or lack of caution, more than stupidity, lack of caution. And we want to make sure that the approach is only does only catch strategic practices by the company, being with respect of its buyers or with respect of its suppliers. I hope I responded.
Thank you very much, Alberto. I thank all the speakers. It was a very interesting debate. And I think the presentations will be posted on the ICF website for the audience. If you would like to go and check the ICF website for all the presentations, they will be uploaded with biographies of the speakers. And I think we're done, Meltem, right?
Yeah, thank you.
Thank you all very much for your attention. Bye-bye.
Thanks for having me. Bye.
Thank you very much, Ebru.
And looking forward to meeting in Istanbul next year.
Yes, all
That
of
would
us.
be wonderful. Yes.
That would be better.
Bye.
Bye. Bye.
Let's go.
I guess in Utah is snowing.
Ebru, we wanted to add that we indeed, for labor issues, we're trying to find a new path, and we wanted to broaden our understanding here in the competition authority. So we even sort of have a young colleague whom we taught to write a thesis on these issues. I think that would next year, maybe in an upcoming month, we're going to include him in another upcoming debate. So Nazir Furkan, so he's the one indeed who have collaborated us in this in writing the background notes, and so I really need to thank him. Thank you.
Thank you.
And we just a quick reminder, hopefully if pandemic stops before the expected time, we want to do this, we want to renew this forum before the third one in Istanbul, so we don't have to wait for next December, hopefully.
The annual conference, sure. Yeah, that's actually very good plan.
In Istanbul again. Thank you, Alberto, and thank you, Ebru. Thank you, Professor Steinbaum, for contributing. Thank you. Happy holidays.
Thank you all. Bye-bye.
Thank you. Bye-bye.